Yeah, she can have normal bed. She just.
I'll let her.
You should sound like it. Good. I thought you were
No. All right, good morning, everyone. We're back on the record on State versus Loyd. Mr. Loyd is present with his attorneys, remains in custody. He's wearing a long sleeve wine-colored shirt, pink tie, civilian pants. He is wearing jail shoes and shackles, but his feet are underneath the table and cannot be seen from any point in the courtroom by the jury. All right, we're going to start with the issue of the juror that the state has moved to strike. Either side wish to present any further argument on that? State.
Yes, ma'am.
Go ahead. It's on. Everything's on. Are you not able to hear? Hold on one second, Mr. Ridgway. We're having a problem with the court reporter. You can hand me what you got, please. Thank you. You want me to try it again, turn it on and off?
Yeah.
Okay. All right, try it now. Can you hear it now? Can you hear me now? Okay. All right, let's go ahead and we'll try it before we start witness testimony.
Sorry.
All right, Ms. Go ahead.
Make sure the cell phones are turned off and put away. That's right there.
Mr. Ridgway, you may proceed.
Yes, ma'am. Your Honor, I've supplied the court and counsel with 3 cases that I think tell us how this has to be resolved. The first case I've provided to the court is Villalobos versus State, found at 143 Southern 3rd, 1042. And I would draw first the court's attention to footnote 6. With regard to the concealment prong, the state argues that Arvinson's failure to disclose was not intentional. However, there is no requirement that the failure to disclose be accompanied by an intent to mislead. Even an unintentional failure to disclose satisfies this prong. So whether the juror misunderstood the juvenile sanction or not is not important, whether she intended to mislead. The fact is, the question, it was misleading. Also, this case addresses the standard to be applied. The court noted at page 146, in determining whether the juror should have continued to serve as a juror in light of his newly disclosed information, the trial court applied the incorrect standard. The trial court focused its inquiry and ultimately the exercise of its discretion on whether there was any reasonable doubt that Juror Arvinson could be fair and impartial. Such a standard is used in determining whether the juror should be stricken for cause. The trial court instead should have applied the standard for jury non-disclosure as established in De La Rosa. And the court lays that out on the next page. First, the complaining party must establish that the information is relevant and material to jury service in the case. Second, that the juror concealed the information during questioning. And lastly, the failure to disclose the information was not attributable to the complaining party's lack of diligence. This case sort of narrows down what the courts had previously done as to the factors to be involved. For example, in the case of Mitchell versus State, found at 458 Southern 2nd, 819, the court laid out a 5-step consideration. question propounded is straightforward and not reasonably susceptible to misinterpretation. The juror gives an untruthful answer. The inquiry concerns material and relevant matter to which counsel may reasonably be expected to give substantial weight in the exercise of peremptory challenges. There were peremptory challenges remaining, which counsel would have exercised at the time the question was asked. And counsel represents that he would have peremptorily excused the juror had the juror truthfully responded. As to the first, I'm not focusing on the public's issue per se, except that I would point out my recollection of the juror who came forward is that her recounting of the conversation was more than she worked at Publix, but that she worked at Publix and had deliberately not answered the questions truthfully. So that's more of an issue than whether she works at Publix or not, is because that leads to what at first was a rhetorical question and later became not, is that if she would deliberately mislead us to that, what else might she deliberately mislead to? The issue, of course, is the two questions. One, her prior criminal juvenile history, and the fact that it was a domestic violence case. The question asked in the questionnaire, have you or any member of your family been accused, a complainant, or a witness in a criminal case? That's about as clear and straightforward as it can get. The fact that the juror may have misunderstood it is irrelevant. Secondly, Mr. Buxman's question to the panel at large, if they had ever been involved or knew of a domestic violence incident, which she may perhaps mistakenly didn't realize that it applied, but the question was straightforward, and her answer, or her failure to answer, her non-disclosure, may have been unintentional, but it was a non-disclosure. So the first two, I think, are met clearly. The inquiry concerns a matter, concerns material and relevant matter to which counsel could reasonably be expected to give substantial weight. The fact that someone has been arrested and the fact that someone has been accused of domestic violence, which led then to, of course, the report showing that there was some perhaps mental health issues, certainly is something that would expect any prosecutor to give some weight to, give substantial weight to. There were peremptory challenges remaining. We had one. Counsel represents he would have peremptorily excused the juror had the juror truthfully responded. I don't know if the court remembers, but Mr. Buxman had finished his individual questioning, and we took a break before we come back for his sort of panel-wide, and he came back and specifically asked her about her employment. And that was because he and I had looked at her questionnaire and her answers, and we had decided we knew nothing about this person. She was young. We knew nothing about her work history, her life history, had no sense of her. And we simply thought she was a risk and didn't like her and considered striking her. But we also recognized we would have had to come forward with a race-neutral reason, and just the fact that we just don't like her because of her life experience probably wouldn't satisfy that prong. We made the decision we wouldn't use our remaining strike on her. I could tell this court that had we known then what we know now, we would have used our last strike to take her out of the jury and bring the next person in as the next alternate. The first alternate would become the next juror. We would have taken her out on a perimeter and had a race-neutral reason for doing so. So I'm asking the court to exercise its discretion to find that the juror has misled, unintentional or not, it's irrelevant. It's material. It was a straightforward question. We had peremptories. We would have used them. The standard has been met.
Thank you, Mr. Ridgway. Mr. Lineman, do you have any further argument? Or Mr. Schwartz?
Good morning, Judge.
Good morning.
Judge, concerning the public's issue, I don't think it's material. Whether she worked there or not really isn't going to have any bearing on their decision. I recognize that domestic violence...
The court reporter cannot hear you. Why don't you come to the podium?
Sure.
Why don't you come over here to the podium where there's
Sure,
an actual
Judge.
microphone? Go ahead.
Better? Okay. So as I was saying, Judge, regarding the issue of her working at Publix or not working there, frankly, I'm still a little bit confused, but it's not a material issue. It's not going to go to any relevance in terms of what the state is going to choose whether to strike her. The domestic violence issue certainly is something that is material. The big issue for us, though, is that they could have discovered this at any point during jury selection. They had plenty of time in which they could have investigated her Apparently, they were able to find it out yesterday after doing a simple search that probably didn't. It's one of the prongs under the Villalobos case is whether there was due diligence by the state in looking for this information. As I said, I don't think that prong is remotely met where you're talking about a criminal record that they could have found. They could have done the simple search that they did yesterday, which they were successful in finding it. In that sense, Judge, I think they clearly fail under that prong. As far as anything regarding the intentionality or not, I really don't think there's any intentionality whatsoever. I think that she just misunderstood the questions in the sense that she hadn't worked at Public, she hadn't got a paycheck from there. Regarding the domestic violence thing, I think all of us do understand juveniles are generally told, you go through the program, you do what you're told, this is going to be expunged, it's going to be off your record, no one's going to see it. And they beat that into your head when you're going through the juvenile process. So I think she genuinely did understand that once she went through there, once it's expunged, it's as if it doesn't exist anymore. That was likely her state of mind when she was answering the questions, Judge. So that combined with the lack of due diligence in the state and finding this information, which, as I said, was readily available to them. This isn't something like, she has a relationship with the defendant going back years and there's no way that they could have known it. In that case, certainly there's no way that they could have figured it out. Here, they could have easily done it as they did yesterday, and their lack of due diligence in that sense fails under the third prong under that Villalobos case, which they put. So we really don't think you should strike this witness. We've gotten this far. We think that it's going to have a prejudicial impact on other jurors seeing that a person got struck. We think it causes a whole lot more problems that's really going to undermine the defendant's chance to have a fair jury, and the court should keep her for all those reasons, Judge.
Thank you, Mr. Schwartz. Mr. Ridgway, you get the last word.
Briefly, Your Honor, as to the due diligence issue, the cases, I think, do not require that we do outside investigation on jurors. The due diligence requirement simply means that during voir dire, we do the appropriate follow-up or whatever if there's reason to do so. I can tell the court we ran criminal histories on all the jurors in the panel. We didn't run juvenile histories. Had this juror said, yeah, I was arrested as a juvenile, as Mr. Schwartz said, within a very few minutes, we could have had this information and known exactly the scope of it. But there's no requirement that we conduct extensive investigations as prior to voir dire as being part of the due diligence requirement.
Thank you, Mr. Ridgway. All right, I took a look at this last night. I reviewed my notes on this. I reviewed the strikes exercised by the state. I'm the one that cited Villalobos, which is Villalobos versus State 143 Southern 3rd, 1042 to the parties. This is July of 2014, 3rd DCA. It lays out the three-pronged test that the Supreme Court of Florida requires us to follow. That was established in De La Rosa, which is D-E, separate word L-A, separate word R-O-S-A, versus Sierra, which is Z-E-Q-U-E-I-R-A, 659 Southern 2nd, 239, Florida, 1995. I agree with the defense that the issue of whether you work at Publix or not is not relevant or material, and that is not what the court bases its decision upon. The issue of the misleading answers that were given as to Publix is, however, something that concerns the court. In going back and checking, I had some additional notes on her, and I did note that the state went back to her after the break, as Mr. Ridgway stated. Mr. Buxman went back to her and talked to her a little bit further because her answers as to her employment were confusing in the first go-round. And my notes indicate, I do not have a transcript, but my notes indicate that one of the things she said to Mr. Buxman was that she had just graduated from high school. She told me yesterday that at age 15 she was in 5th grade. Those two things cannot both be true. She did not reveal in any way, shape, or form to anyone that she had been involved in a criminal case. The question on the questionnaire is quite clear. The case law does not require that to be intentional. It just requires that you not reveal it. The state did strike several people who had revealed domestic violence backgrounds. The state did have one more strike left.
I don't find their assertion that they would have used that strike to be unreasonable. It's the state's position that they would have used that strike appears reasonable and credible to the court. And I'm concerned about the fact that this juror's answers have been consistently misleading. Whether it's intentional or not, I don't know. I'm not sure it is, but they are consistently misleading. And although at any time a court is reluctant to strike a juror, I believe that the state has met the Villalobos versus state standard. And at this point, I am granting the state's motion over the defense's objection and striking this juror. She will be substituted by the first alternate. The court notes for record purposes that the juror being struck is an African-American female, and she is being replaced by a gentleman who appears to be an African-American male. That does not change the racial composition of the jury, but it does change the gender composition of the jury. So we'll bring that juror out, please. It is juror number 712. Have a seat, ma'am. Good morning. Ma'am, as you know, I asked you some questions yesterday about the answers that you gave during General voir dire. After examining the situation, it appears to the court that your answers were not accurate in some respects, and therefore at this time, I am striking you as a juror in this case. You are excused from jury duty in this case and discharged. The deputies will take you back to the hotel to pick up your things, so you're free to get on with your life. We appreciate your service. We appreciate your being here, but at this time you are excused. Thank you. Ma'am, you need to come this way. All right. Anything else we need to address before we bring the jury back in and start back with questioning? And I have a question for the state. The Walmart testimony, I need to read a Williams rule instruction to the jury prior to that. So when is that starting?
Require from the juror who reported this, whether she had communicated with anybody else in the jury, you had not instructed her not to, and so I would ask her to inquire on the issue.
To what end? To what end? The only thing, to what end?
Whether she spoke with it to anybody about you before she wrote the note, and who that was, and whether she spoke to anybody after this.
The only thing that juror told me was that this juror had deliberately lied about working at Publix, which isn't a material issue, whether she worked at Publix. But you want me to inquire as to whether or not she told other jurors that?
She actually testified, Judge, that this conversation was occurring around dinner time table, while all the other jurors were present. I want to find out if she had conversations with other people about this, whether they talked about writing a note, whether they designated her to write the note, or any information that indicates that she did this on her own completely without anybody's knowledge up to this point, or whether other jurors joined her in something.
And to what end do you need that information? I mean, inquiries of jurors are something that, as you know, we keep to a bare necessary minimum during trials.
Before you wrote the note, did you talk to anybody about writing the note?
I'm not asking you what questions you want me to ask her. I'm asking you what is it that you think this information goes to?
It goes to whether there are other jurors who have information that are privy to this, whether they had failed to bring this information up, they had additional information, whether they talked about this amongst themselves, whether they violated any court orders during this process. It goes to all of those things.
State?
No, I don't think anything the juror said would suggest it violated any of the court's orders. She said they were just all talking about work. And again, I think I don't see, again, to the court's question, to what end, my answer is I don't see one.
Yeah, I don't see any need at this point to ask any further questions about this. What the juror told me was that this was a dinner time conversation, that she decided to write a note because if it was going to, I'm paraphrasing what she said, because if it was going to cause a mistrial, she wanted it to happen earlier rather than later. She didn't want to sit through the whole thing. There's no indication from this juror that she spoke to anybody else about it, that it was a general conversation about the case itself. What it was a conversation about this juror saying that she had not told the truth. None of that goes to any issue at this point that's been raised before the court that would require further inquiry. Right? So, in answer to my question of when you're going to start the Williams rule evidence.
The next witness, Your Honor.
The next witness? All right, so I need to read it as soon as they come out. All right, let's bring the jury out.